Salutations to all our future judges. In this video, we are going to see Indian Evidence Act 1872. But before going into the video, I'd like to make few requests to our viewers as well as the subscribers. Kindly do not skip the video. Watch the video from the beginning till the end. If you skip in between, you may be missing very crucial information or very crucial aspects which have been explained. Hence, watch from the beginning till the end. And next request is, please do have a notebook and a pen with you, because various questions which have been asked in Evidence Act in various exams would be mentioned or would be stated. And in addition to this, idea would be given as to how questions could be framed in a particular section. It is very important for you. So you all need to make a note of all these aspects. And in addition to this, some additional illustrations would also be given while teaching the act. Hence, you please make a note of all those additional illustrations as well. They would be of absolute help to you in understanding the particular section. And in addition to this, various ways or techniques would be taught which would help you to remember those sections, or to say some memory techniques would be given. This would be really helpful to you in remembering the sections when you go to the exam. I hope this video would be of absolute and great utility to you. Section 155, Impeaching Credit of Witness. So there are two scenarios in which the credit of a witness may be impeached. The first scenario is by the adverse party, and the second scenario is by the party who calls him with the consent of the court. To understand this in a very simple manner, if I am calling a witness to the court, then I can impeach the credit of that witness with the consent of the court. On the other hand, my opposite party or the other side advocate can impeach the credit of my witness without the consent of the court. Let us see what are the ways in which the credit of a witness can be impeached, or what are the modes in which you can make this happen. The first one is, if evidence is called and he testifies in the court that from his own knowledge about the witness, he believes the witness to be unworthy of credit. Let us try to understand this in a much more simpler manner. I am calling an evidence. The opposite party wants to prove that my witness is not worth of credit. So what he does is, he brings another witness to prove that my witness is not worth of credit, or that witness is unworthy of credit. That person, he comes to the court and says, so and so witness is not worthy of credit because I have knowledge about the witness. From my knowledge, I know that this person cannot be relied upon. That is the first way in which we can prove this. Second is, by proving that a witness has been bribed or accepted the offer of a bribe, or that he has received any other corrupt inducement to give his evidence. In all these cases where we prove that either bribery has happened or an offer has been made, or an offer to give bribe was accepted, or any corrupt inducement has taken place, in all these cases that witness cannot be obviously relied upon. The third is, if a person gives a statement which is inconsistent with any part of his evidence, which is liable to be contradicted, this can also be taken as a way or mode in which we can impeach the credit of a witness. So these are the three ways in which we can make this happen. Let us try to understand this particular explanation. Now, this is the witness box. In this, witness A is standing. This A is saying, witness given by B cannot be relied upon. He is unworthy of credit. He is unworthy. A is stating so. Now, the person who called this witness, he is chief examining him. This advocate who got A, when he is asking question to A, he can not ask as to why you are saying that B is unreliable. He cannot ask that question in chief examination. But whereas opposite advocate can ask this question to A as to why you are saying that B is unworthy of credit. He can give reasons. But the point is, if this A is saying a false fact, then what can be done? This fact cannot be contradicted. It cannot be contradicted. However, if it is proved to be a false evidence, then A can be convicted or can be tried for giving a false evidence. So this is what the explanation says. Now, let us move to the illustrations what have been provided. These illustrations will give you a very clear idea about this particular section. Illustration A. A has delivered certain goods to B for a particular price. Goods are also delivered. Now, a third party C is coming and is saying that he delivered the goods to B. Then evidence is offered to show that on a previous occasion, this particular C said that he has not delivered the goods to B. The evidence is admissible. Let us try to understand this in a much more simple and easy way. I am giving goods to you. Your friend C, he is seeing this. He is coming to the court and saying, yes, I have given the goods to you, and he has seen it. Now, an evidence is given to show that your friend is saying something false because in a previous occasion, he said that I did not deliver goods to you, which is contradictory. In one place, your friend is saying that I delivered goods to you. In another place, in the same scenario, he is saying that I did not deliver goods to you. These two are contradictory. So in this case, the evidence is admissible. Let us move to the next illustration, B. A is indicted for the murder of B. A has murdered B and action has been initiated or trial has commenced or proceedings are going on, whatever it may be. Now, a third party C is coming into the picture. He is saying that the B, when dying, declared that A stabbed him and he caused a wound, due to which B died. Now, evidence is offered to show that on a previous occasion, C has said something contradictory. He said that wound was not given by A or in his presence. Then the evidence is admissible. I am seeing someone dying. I am going and asking that person. That person is saying, sir, I died because of the wound caused by A. Now I come to the court and say, yes, I spoke to the person who was dying. He told me that this A had stabbed him or A has caused a wound due to which B died. This is the statement which I give in the court. But on a previous occasion, or maybe when police investigated, or in the previous cross-examination, I have told to the court or to the police or the investigating officer that A did not cause the wound and this wound was not caused in his presence. Then in that case, the evidence is considered to be admissible. This is section 155. Now let us move to section 156. If there are questions tending to corroborate evidence of relevant fact, then that is admissible. With respect to this particular section 156, we need to understand one aspect. If I am saying something connected to the fact or the main problem, then that is admissible. They are given an example. By trying to understand that example, we'll understand the concept which has been explained in section 156. Imagine I am being tried for a murder. In that case, a witness is coming and is saying some facts which are relevant. However, there are certain incidents which happened around that murder or in that area or at that place or at that time. Then the court will see whether it is relevant to the case in hand, whether it is relevant to the murder. Then the court will decide whether it will corroborate the testimony of the witness as to the relevant facts. For example, if I am saying that the murder which happened was at a particular place, at a particular venue, and at that time when this murder happened, there were three people standing and drinking tea near to that spot. If I'm saying so, if imagine I'm the evidence, I'm saying so. In that case, whether that will help to prove this, then if that corroborates with the relevant fact, then that can be taken into consideration. Imagine those three people who were drinking tea came and deposed before the court as a witness, and they tried to prove to the court that murder did happen and this was the person who caused the murder. Then in that case, that can be accepted. Now let us move to the next illustration. What has been provided in under the provision? A is an accomplice. There is a robbery which took place. He is an accomplice. He took part in that robbery. Then he describes so many things which happened, which are unconnected with the robbery, which occurred on his way to and from the place where it was committed. Imagine this fellow is going from spot A to spot B. While he is going there, the B spot is a place where murder happened. He is going from spot A to spot B. Spot A is, for example, the house of the accomplice. Spot B is the place where the particular robbery occurred. While going, he is seeing a car which is kind of weird. He says, like, I saw a very weird car which was actually running with a single tire or say some two tires. He can say something like that. It was so weird. I just remember this. He's saying so in the witness box, standing in the witness box. Court is recording this. Now the court is verifying whether such a thing has actually happened. If that has happened, then there is a good probability that this robbery could have also happened. So what the court will try to do is, it will try to connect things which happen around that robbery, and they will try to connect that particular incident to the robbery, and they will identify whether the robbery actually took place. Then independent evidence may be given to this particular aspect, saying that there was a weird car which was running at that time. Someone can come and give evidence with respect to that particular aspect. That can also be considered. And independent evidence of these facts may also be given to corroborate his evidence as to the robbery itself. So these kind of aspects are supportive to the main aspect. As simple as that. Main aspect is maybe robbery, murder, or it could be any other grave offense. So anything which is connected to an offense or which is happening in a particular scenario or a particular place, evidence can be given with respect to that particular aspect to substantiate the offense. With this, section 156 is concluded. I hope you would have liked the video. If you like the video, please do press the thumbs up button and do share the video with your friends and motivate them. If you are not subscribed the channel, please do subscribe the channel and share the channel with your friends. If you feel that I've left something in this video, or you want me to change the way in explanations are given for the sections, please do let me know by way of comments. Let us join hands together and contribute for a learned society. Thank you.